אז אני עוד לא סיימתי את זה, אני יכול להפסיק. זה מעניין. אולי אנחנו לא חושבים את אותו דבר גם.
זה הכי מעניין.
That's what he tells me. Can I press? Just press. We'll ask him.
כן, כן, אני מחכה, אני מחכה.
You're going to talk first.
Okay, good afternoon, ladies and gentlemen, those of you who decided to skip the afternoon nap and to stay with us here. This is the third session that will begin right now, and this session is about the media coverage and the ethical dilemmas that are involved in this area of reporting, of journalism. Freedom of speech versus due process. Who will win? Who will the judge decide in favor of? And as an opening address to the session and the panel that is already seated here, I would like to call the President of the Israeli Press Council, retired Supreme Court Justice Dalia Dolan, please.
Okay, can you hear me?
Yes, very well.
Good. Good afternoon. Freedom of speech versus due process of law is not an easy question. There is no doubt that freedom of expression is one of the hallmarks of a democratic society, and that transparency in the criminal justice system is essential. In the words of Bentham, publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all grounds against improbity. It keeps the judge himself while trying under trial. Coverage of court cases by the press enhances public knowledge and appreciation of the enforcement of the law, and it permits the revelation of matters of genuine public interest. The media performs a watchdog role in relation to the criminal justice system by discussing the broad issues of public concern which may arise in a criminal case. It does so by discussing ethics, behavioral norms, and the desired or current law. The protection of the administration of justice from the undue influence of the media in individual cases is sometimes necessary. However, I believe that where the publication relates to a matter of public interest, the potential threat to a fair trial is outweighed by the public interest. The aim of the sub judice rule is to prevent the publishing of material that may prejudge issues at stake, or which may influence or place pressure on persons involved in the proceedings, including witnesses and jurors. In deciding whether the material is prejudicial, the public interest in free speech must be balanced against the public interest in ensuring a fair trial. Freedom of speech should not be limited to any greater extent than is strictly necessary, but it cannot be allowed where there would be a real and severe prejudice in the administration of justice. How are we to know when one interest outweighs another? Justice Cardozo answered in his article, The Nature of the Judicial Process, that the judge must get this knowledge from experience and study and reflection, in brief, from life itself. Well, that's a problem, no? The generalities of the sub judice rule have content and significance that vary from state to state and age to age. In this decade, the advances of technology render the recycling of information an almost unstoppable phenomenon. Any internet user can easily obtain prejudicial material concerning a person on trial for a criminal offense. So the broad sub judice rule which purport to control the flow of information, has become outdated and ineffective. Still, the traditional media retain the power to influence public perceptions. Research recently published indicates that digital devices get 10 times more media time than newspapers and magazines. However, the extended time consumers of news spend with print compared to the relatively short session on digital multiplies its share sevenfold when news consumption is considered. The balance depends on whether trials take place before juries, as in other countries, or before professional judges sitting without law jurors, as in Israel. The sub judice rule assumes that if the court is exposed to media material about a trial, which is not part of the evidence presented, tested and argued in the trial, the court may be hindered from reaching an impartial and proper verdict. In trials before professional judges, this assumption is doubtful. Nevertheless, the justice system must strive not only to achieve a fair result, but also to ensure that it is apparent that a fair result has been achieved. Justice should not only be done, but must be seen to be done. Accordingly, it can be argued that if the media publish prejudicial material, they can appear to urge, or may in fact be urging, a particular finding. The media can wage a campaign against one of the parties to the proceedings. If the court decides in accordance with the outcome promoted by the media, it may appear as if the court was swayed by the media. By the same token, if the court's decision does not accord with media opinion, it may appear that the court was deliberately acting against it. Either way, it may appear that the court's decision was not impartial and was not based on the evidence presented in court, even if it was. But while the interest in protecting the public trust in the propriety of judicial proceedings cannot be disavowed, we must remember that this protection is largely speculative. Moreover, there is a publication which relates to or promotes a public interest may cause an interference with the administration of justice. In my view, such an interference may be excused from being considered contemptuous. So the question is whether the subjective rule must be regulated by the criminal law, or it can be regulated by the media's professional ethics. The law in Israel states that anything on a criminal matter that is pending before the court cannot be published with the intent or foresight as a close possibility that the publication could influence the outcome of the proceedings. The maximum penalty for violating this provision is a year in prison for the journalist and a fine for both the journalist and the newspaper. This definition is very broad and contains only a vague rule of a chance of influence, the nature of which is unclear, especially as we have no jury. And therefore, in practice, the criminal prohibition is not enforced. Given the drastic nature of the criminal law, it is preferable to revise the sub judice law and replace it with ethical standards that journalists willingly adopt, especially in view of the fact that in Israel today the existing criminal prohibitions have practically been unenforced. So that the issue is in fact one of establishing rules in a sphere that is not that was not and is not regulated in practical sense. Indeed, our code of ethics contains guidelines for reporting on legal proceedings. According to these guidelines, a clear separation should be made between reports on actual courtroom proceedings and any commentary on background analysis. The guidelines forbid journalists who are covering court proceedings for making any attempt to influence the outcome. For example, while a trial is still underway, no opinion should be published about the testimony or argument presented in court by either side. Separate commentary may be published, however, including critical assessment of a judge's ruling. Well, at the end of the day, it is very difficult, the balance to get right. However, I'm hopeful that efficient specific guidelines can be written, since it is in the interest of the media to comply with rules concerning the manner in which they work, given the ongoing nature of their work. Thank you.
Thank you, Justice Dorner. And a few words before we begin the session, a few more words about sub judice, which for some reason in the Hebrew language we say in the German accent, sub judice. So a few words about sub judice in Israel. For years everyone said, like Justice Dorner has mentioned, that sub judice provision is as good as dead. No one will ever enforce it. So they said. Justice Gidon Ginat from the Tel Aviv District Court was not impressed. In late 2012, there was an indictment against one Shimon Kupel for murdering two of his former wives. The indictment was submitted after a police investigation that would not have occurred if not for an extensive journalistic research made by TV program Uvda on Israeli Channel 2. Only after the program discovered that the police had initially closed the case without indictment, it was reopened and the suspect was eventually brought to justice. After Cooper, the defendant, was indicted, the program wanted to revisit the issue and prepared a second item. But only 4 hours before it was supposed to air, Justice Ginat granted the defendant's request to ban the broadcast that, as Cooper claimed, was about to harm the principle of fair trial. Article 71 in the court's law says that no one will publish anything about an ongoing criminal trial with an intention to influence the trial process or outcome. Is it a proportional step to issue a gag order based on the rationale of sub judice, which is a criminal provision in the legislation? The criminal law is meant to bring justice, to justice whoever breaks the law. A gag order that prevents in advance anyone from doing anything, especially in the area of freedom of speech, is at least questionable. The good people of Uvda had to find something else to air that night. But 3 months after that, the Supreme Court overturned Justice Ginat's decision. The 3-judge panel in the Supreme Court clarified that when dealing with the criminal norm of sub judice, a preemptive gag order is not automatically in order. My name is Yuval Yoaz. I'm a journalist. I cover the legal field. I'm a legal journalist for Globe's newspaper. And let me introduce our panel members. We have Professor Kubus van Rooyen, who is the chairman of the Broadcasting Complaints Commission of South Africa. We have Mr. Yevgeny Obov, who is vice chairman of the Russia Press Council. We have Dr. Muhammad Watab. He is a law professor from the Sefard Academic College School of Law. And we have Dr. Isgav Nakdimon, Advocate Dr. Isgav Nakdimon, who is the General Counsel of Channel 2 News in Israel. Welcome, gentlemen. We will begin the session. I would like to begin with you, Professor van Rooyen. And the topic is the freedom of expression, opinions, of expressing opinions in media on a trial, during the trial. Professor van Rooyen, please.
I've, contrary to my style, I've even prepared something which we could look at. But I'd like that. If we see Table Mountain, then we know we're there. If we don't get Table Mountain, we won't get to Oscar Pistorius either. So I've got some snapshots. Yeah, he's pressed F5. My son told me F5 opens it up. I think will I be able to just press a button to the next one? Is that right? Thank you very much, Will. Justice Dormer, I'm so sad that you're not on our court because I'm in trouble in South Africa. We came to a decision saying that including the view of a mother of one of the, I must say, maybe 20 raped people of the Sunday rapist. He was named the Sunday rapist, this guy. And what happened was, and this is the background to today, for me, I'm in trouble because they're taking me to court for this. The first time in 20 years. I feel very low, so I feel much better after having heard you. But what happened was, on the last day of the Sunday Rapist trial, he's been called Sunday Rapist right from the beginning. In contrast to that well-known song of Never on Sundays, Sundays was his day. And I'll show you his picture just now. What they did, one of the radio stations, is that they said, the Sunday Rapist yesterday denied all charges. He said he never knew anyone. He never even met them. Whereupon, we didn't know this, by the way, in court, the mother shouted from the public gallery, "You're lying, you're lying." Whereupon the judge told her she must keep quiet. So what happens is the press then goes to her afterwards and says, "Ma'am, why did you say you're lying?" She says, "Well, you know, if he took them, he must have known them." It's a really sad story, though. I mean, I feel so sorry for the mother. I mean, it's a terrible story. And then they published that the next day. And I won't blame you. I find the older I get, the more conservative I am, because we come from a British tradition of sub judice. It's in Canada, it's in Israel, it's in South Africa, probably also in Australia, etc. It's a typical British tradition which has a lot to do with jury trials. We made a finding against them. We said that's not fair. The news rule says news must be fair. This is not fair, we said. This was confirmed. We have an internal appeal system, and it was confirmed. We even had a retired judge as co-opted member there. Okay, I'll just leave it there for a moment. We've been taking, for the first time in 20 years, on review to the Supreme Court. That doesn't mean appeal, as you would know. It's just, if they think we were blatantly wrong or something like that, they can refer it back. Okay, that is Cape Town. That is at least the peaceful scene which Jan van Riebeeck saw without the buildings when he arrived there in 1652. And this is the name of the subject, the sub judice rule, and sad to say, here is the Sunday Rapist. If you look at him, you will understand that people just called him the Sunday Rapist. But it's, on the other hand, for a lawyer like me, getting older, it's hard that even if you look like that, to be called the Sunday Rapist already, and the mother then chipping in and says he's lying on the radio to thousands of people. So maybe we did make a mistake, but this is what our decision was. There's the Sunday Rapist. Can you see the challenges to the rule of sub judice? Here's an intervention which would never have been allowed in pre-constitutional times in South Africa. But the Constitution, section 16 of our Constitution, says freedom of expression is guaranteed. And relying on this, the press is going much further. Maybe they're right, I'm not sure. Maybe I'm just old-minded. And here is the Modimolle monster. He was constantly called the Modimolle monster. I said rape and murder on the Nile, thinking about Agatha Christie to a certain extent. But the Nile is the place where a group of people, just to make it more interesting, it's afternoon, it's matinee, you know, a group of people in about 1860 travelled away from the Cape, very conservative Christians, and they were looking for the Nile. So about 900 kilometers from Cape Town, they find a place which is, they then name Nile Stream. They even see a pyramid there, which happens to be an outcrop in the mountains. And they say, now we are close to the Holy Land, and we start to build a church here. I'm trying to show you the contrast. Very good people going up there north believing it's the Nile. And you know, if you've been there, it's thousands of miles up to the Nile. And then in contrast, you get the Modimolle monster who comes from Nile stream. He's in a terrible relationship with his wife. He has her raped by 3 men. He kills her son, and the press dubbed him the Modimolle monster. Well, it's so interesting, you'll see, I'm going to say something at the end, I'll get back to you. He's found guilty, he's going to get life, 10 lives more or less, I don't know, he's guilty. But remember here, he's still on trial. There he's sitting. He pleaded that he was a narcissist and that he was, you know, he didn't even know what was happening. But my wife said to me, no, don't be silly, he's a monster. But I'll get back to that just now. Sorry, I don't mean anything bad about time. I'm an avid reader of time. The guy who put this together for me decided he would go for that. Now we all, well, many people know Oscar Pistorius, the Blade Runner. The blades, by the way, are made in Iceland. They are very worried there. Superman, gunman. The press afterwards went and said, he's a great collector of guns. So can you see, it's building up harder and harder for him. And then they illustrate what happens in South Africa. And now I must say, I want to really promise you, people often say it's such a violent country. Yes, it's true. But I mean, I've been living there for years, and we are careful, that is true. But at that time, there used to be, and they've arrested them now, the Waterkloof gang, ex-policemen figurating as, and it was really a bad time. We were really also worried to go out in the evenings because the Waterkloof, that's where I lived, the Waterkloof gang was rampant. Maybe his advocate, who cost something like 70,000 rand a day, something like that. It's what's about $8,000 a day, $10,000. Doesn't matter, he's a billionaire. And I'm not saying anything against time, because in the article they explain, well, he's collected guns, and that within the atmosphere, that violence is more there in the country. So, nothing against time, it was just an interesting article. If it doesn't work, I'll just drop this. It's Oscar in court. But let me just show you, you won't be able to see very well. Then one of the big Sunday newspapers comes up. There you see Oscar. Now it's after he's waiting now, he's got bail, he's got easy bail conditions, he can leave the country, and so on. Then suddenly they're looking again in a Sunday newspaper, they're saying, Oscar takes a beautiful young woman to see his racy 1.5 million Audi 8. Can you see the problematic world for Oscar now? Can you possibly, they say, and then beautiful, beautiful young woman. You see her there at the right. You might not be able to, in the dark it would be better. She's really beautiful, wonderful girl. Happens to be his cousin. I know. I know his uncle. It's his cousin who went with him to buy a car for her father, who's a billionaire. A billionaire who would love to have this Audi R8. He helped, because he had a lot of time on his hands, he helped with the paperwork. So what do they say? Already has a girl. I know that girl, she grew up before me. Oscar there, at a garage, racing. So the press ombudsman decided to make Rapport, the Sunday newspaper, apologize for this mistake. But can you see, with great respect, like people are trying, it's there. It's in the air, making it, and it's not just this, you know, the gunman idea. He's got a huge collection of guns. And can you see the tide becoming difficult for Oscar? Why do I conclude with the Archbishop, Nobel Peace Prize winner? On the Modimolle monster case, he wrote something in a newspaper. He said, stop, please, stop calling this man a monster. God created, you know, it comes from his heart. God created us equal. You cannot call someone a monster. I mean, he's really, as you know, a world-renowned leader. And I agree with him. Not with my wife, I agree with him. I wouldn't tell my wife. But can you see how someone more traditional would say that all humankind, no one can be a monster, all created by God. And someone then reacted, and I'm just saying this very closed, saying, you can see he's becoming senile. Well, I'd be happy to be senile with him. So, yes, this sub judice rule is under enormous pressure in South Africa as a result of Section 16 of our Constitution. For me, as a traditionalist, I'm concerned about it. I've just shown you a little few cases. The Sunday rapist, called that, Modimolle monster. And now remember, within the South African context, there was so much suppression that there's so much, let me put the side of the press as well, there's so much joy for the freedom. But as a little bit of a conservative on especially the legal side, and having also sat as a judge for 6 years, I'm on the conservative side, and I'll leave it for you to think about it. It's maybe, it's good for South Africa to have greater freedom here and not go back to the old days, as I tend to do. But I'm perfectly happy to decide in future, watch out. Don't just take a decision when the mother comes in and says, he's lying, because maybe people see it in a different perspective. They would say, yes, it was the mother. Why not give her a chance? So on that double note, I thank you for the privilege to be here, and Arik and Madame Justice, it's an honor for me to have been here and to congratulate you on this absolute miracle conference. Thank you very much.
Thank you. Stay with me for 1 minute, because I would like to ask you a question.
Cross-examine.
Just a follow-up. If I followed you correctly, you say that naming names, making brand names to defendants who are involved in criminal proceedings is wrong by the media. But suppose there were no brand names like that. What is a fair coverage of those kinds of trials?
Yes. What happens is that they usually say the so-called, but after a while it just falls away. So maybe this is the new thing. For me, I expect a fair trial for the worst of people, for the worst. Had they called Mandela a traitor right from the beginning, I would have rebelled against it as well. I'm a traditionalist. I'm very much, and I've sat in so many trials where people had sat 5, 6 years and we set them free because they had wrongly been convicted, that maybe I'm biased in favor of the accused because he must have, or she must have, a fair trial and not be called the Modimolle monster. I'm saying this from my heart, but knowing that I'm getting older, I must watch out a little for myself.
Thank you. Thank you, Professor. Thank you, Professor Van Rooyen. Our second speaker from Israel, Dr. Muhammad Watad. And Dr. Watad will speak of the analyzing testimonies and evidence in the media before they are submitted in an ongoing trial. And the example that he will address is the famous example that we had here of the trial against President of Israel, Moshe Katsav, who was eventually convicted of rape and is serving 7 years in prison. Dr. Wattel, please.
Good afternoon. As provided by the previous speakers, I'll be talking today about the role of sovereignty, especially in the context of the potential clash between the constitutional right to free expression and, on the other hand, the constitutional right to due process of law. In Israel, as in any other countries, the law provides that it's a crime for a person to commit or to comment publicly on a pending criminal case if he or she aims at affecting the trial proceedings and or the result of the case, whenever such commentary might prejudice the court's opinion. This has been the case, as we learned, in South Africa, in England, in New Zealand, in Australia, and other countries. As it stands today, in my humble view, this criminal prohibition called sub judice strikes a proportionate balance between the constitutional right to free expression on the one hand and the constitutional right to due process of the law on the other hand. This prohibition becomes relevant usually, though not necessarily, especially in the context of holding public figures accused for criminal trials, where the media and the press are highly interested in covering such trials. In a constitutional democracy, free press and media is one of the most prominent features for the constitutional right to free expression. Not only it's a constitutional right for the public to know that which may or might affect their social and political environment, but also and primarily it is the state's interest to promote notions of democracy, market of ideas, and truth exposure. In the same vein, it is a constitutional interest to protect the public's right to dignity, namely to treat the public as a collective of human beings, as subjects rather than objects, as ends rather than as means, thus emphasizing the public rationality as a collective, again, to affect and to be influenced of the surrounding social and political events. This is being said in general, but especially true when a criminal case of a public figure is at stake, all the more so political representative figures. Correctly, the media tends to grant such cases more attention, inter alia for the good purpose of fulfilling the public right to know, thus protecting the public dignity as well as providing a more substantial meaning to the media's constitutional right to free expression as an independent interest, but also for the sake of revealing the truth through the creation of a public market of ideas. Having said that, still it is of the utmost importance to remember that in criminal cases, the accused is presumed innocent until proven otherwise. Like in other Anglo-American legal systems, Israel's criminal law of procedures does not permit the reveal of any kind of evidence before the trial judge, but only through the conservative tools of the adversarial system, namely in the courtroom, according to the sharp and clear regulations for permissible and impermissible evidence. Obviously, the idea behind that is keeping the trial judge away from any prejudiced materials, thus allowing him or her to decide on the case before him or her as objectively as possible. The trouble is that in modern societies, with the fast development of technology, including all sorts of public and private media, all the more so the social media, trial judges cannot pretend to be so objective. For it is a self-evident truth that in the absence of any legal and formal regulations which prohibit them from reading newspapers, watching television, and listening to the radio, like all of us, trial judges are highly exposed to the media, coverage of criminal cases that are brought before them. As such, they might be already prejudiced on the case matter before them, or at least suspected as such. This is why, first and foremost, the sub judice prohibition was originally formulated. Since its inception, there have been a very few cases where the general prosecution of the State of Israel employed its power to submit criminal indictments against those who manifestly violated the sub judice prohibition. This is being said particularly due to the large number of occasions where the crime of sub judice took place. In many cases, the trial judge himself or herself even commented on this matter, thus raising an eyebrow on the prosecution's reluctance to act where it's necessary. Leading among other cases, it's worth mentioning and emphasizing the Hanigbi case, one of the members of the parliament who was found guilty for the crime of false testimony, the Ramon case, who also was a member of the parliament who was found guilty for the crime of indecent assault, and the most recent and famous case, the Katsav case, used to be our president, who was found guilty for several sexual crimes. In the above-mentioned cases, the television screen has been turned into a trial court. Not only legal experts were interviewed, I was interviewed as well, but also witnesses provided their testimony to the public prior to testifying before the trial judge. In other instances, even cross-examinations of such witnesses took place at TV studios. Worse than that, the criminal record of the accused was discussed live on TV, although it is both irrelevant to the guilt finding and establishes prejudice insights against the accused. And finally, hearsay evidence, which otherwise are impermissible to be submitted before the trial judge, has been expressly the subject of live and hot TV talk shows. How can we then expect trial judges to be so objective and unprejudiced in making their decisions? We simply cannot expect them to do so. It is even a big disaster to imagine that these judges are exposed to any public pressure as a result of any media interviews. If we are serious about constitutional law, and if we deem the presumption of innocence as a meaningful institution, we shall pay more and closer attention to the sub judice prohibition, all the more so to its meaning and subsequences. Obviously, I am not asserting today that criminals should have been acquitted simply because the crime of sub judice was committed. However, I am here today to argue the following. First, if the guilt finding is based on evidence that otherwise would have been impermissible in court, then indeed it is my view that such finding cannot and should not stand anymore. Second, the general prosecution should be more serious about the words of the law, thus enforce the crime of sub judice more often whenever the prohibition is being violated, and it has been violated more than once. To end up with, I would like to suggest that trial judges who sit in criminal cases of public figures and or in publicly discussed cases be held away from the public and the media for the time being until the trial is concluded. In offering this proposal, I shall remind the Israeli judiciary that it is according to the Israeli law of procedures that criminal trials ought to be heard in a day-to-day basis as well as swiftly. This has been the case for the jurors in criminal cases in the American legal system, and I see no good reason why this cannot be applied in Israel. For the time being, let us hope that public figures will be decent enough to the extent that there will be no need for criminal trials on the one hand, and therefore no need to discuss this rule. To conclude, I don't think that the question should be that which right prevails, the due process right or the freedom of expression right. The question rather is a question of the balance that should be struck. Where do we draw the line? Thank you for your attention.
Thank you, Dr. Wata. Just a few notes, if you would like to respond.
By standing?
Whatever is more convenient for you. You can stay here. As you remember, when former President Katsav was tried, there was a 3-panel judge in the Tel Aviv District Court, and after he was convicted, they sentenced him to 7 years in prison. 2 of the judges thought he should serve 7 years. The third judge thought that his sentence should be shorter and he should only serve for 4 years in jail, and she explained her opinion by saying that part of his punishment was already that he was trialed by the media and got his punishment from the media coverage of the entire proceedings. So do you think this kind of reasoning is legitimate, is okay?
I do understand this kind of reasoning, although I don't think it is a legitimate one in the criminal law theory. Because basically every case nowadays, somehow in the media, whether we're talking about public figures or not, it's the same as we say sometimes when somebody is involved in a car accident and he loses one of his beloveds in this car accident. We say he has got his punishment from God. Well, that's fine that he got his punishment from God, but legal theory aims at different purposes, and we should not mix up these things. However, I take this commentary by the third judge as alluding to another theory of criminal law, which I think my friend will be talking about that today, which we call in Hebrew Hagana min hatzedek, that is to provide somebody a kind of a mitigation of the sentence based on some abuse of rights that occurred to him during the trial proceedings, and that should be fine.
Okay, thank you very much. Our next speaker, as mentioned, is Dr. Isgav Limon from Israel. He's the General Counsel of Channel TV News in Israel. He also spent some time on the bench as a magistrate court judge. And yeah, a short period of time. I tasted from how it looks like from this side of the courtroom, and now he's back with us. Dr. Limon, please.
Good afternoon, ladies and gentlemen. I would like to focus on the very famous affair that we had here in Israel the last years, and I mean to the criminal trial of our former president, Mr. Moshe Katsav. I would like to address this subject in light of the sub judice rule, and I would like to say a few words about dismissing indictments against public figures due to what is sometimes called a trial by the press. The section in the Israeli law regarding the sub judice rule was cited before me, and I will not repeat it. There's also the rule of the Israeli Press Council that was cited by Justice Dorner, which states that in their reporting, a newspaper and a journalist shall respect the fundamental principle that a person is presumed innocent unless found guilty as a matter of law, and that in reporting the criminal proceedings, there shall be no manifestations of any apparent intention to influence the outcome of the trial. In particular, during the course of the trial, no adamant assessment of the testimony or the positions of the parties or a position concerning particular outcome of the trial shall be published. The question I would like to discuss is, does a breach of these rules should and could affect the outcome of the legal proceeding itself? For many years, public figures that were indicted in Israel claimed that hostile publication that appeared in the media should be considered by the court to mitigate their sentences. Some of them, as former Minister of Interior Aryeh Deri and former owner of the Ma'ariv Israeli newspaper Ofer Nimrodi, succeeded somewhat in that path of argument. Others, such as former Minister of Treasury Avraham Hirzon and former Minister of Energy Gonen Segev, did not. You see how many ministers and high officials in Israel are being indicted in Israel. Under recent developments in Israeli constitutional and criminal procedure law, a new path arises in taking hostile publication as to the accused consideration while reaching the outcome of his trial. It is the Israeli legal doctrine of due process which allows the court today to dismiss an indictment when its submission to the court or the proceeding based upon it are being found as contradicting the principles of justice and legal fairness, what is called in English law abuse of process. The English law from which the doctrine was received into Israeli law finds hostile publications as to the accused as such that can justify, in the appropriate circumstances, a stay of criminal proceedings. This perception is based on the danger that the accused shall not receive a fair trial within a legal system which tries him by a jury that can be influenced by out-of-court media publications. But is it appropriate to apply this doctrine in such circumstances to a legal system that tries criminal defendants by professional judges as it is in Israel? Such application of the doctrine can be based upon two main rationales. The first rationale is based on the view that trial by the press undermines the presumption of innocence and creates a persecution of the accused. According to this rationale, in extreme circumstances in which the public has elected to take the law into its hands by trying the accused in what is called the town square, it is precluded afterwards from continuing the trial in the regular framework. The second rationale is concerned with the fairness of the trial in extreme cases. It takes into consideration the principal recognition of the Supreme Court of Israel of the reasonable possibility of media publications' influence also over the professional judge, and not only upon a layman juror. The trial of former Israeli President Moshe Katsav, that drew extensive media coverage, was a significant test case regarding the possibility that an Israeli court, assembled by professional judges, will consider to dismiss the indictment due to the hostile public atmosphere that surrounded the accused. A hint in that direction was given in one of the first stages of the Katsav affair, when Supreme Court Justice Edmund Levy wrote, while considering the reasonableness of a plea bargain with Katsav that afterwards was withdrawn, that criminal defendants may claim for a violation of due process in light of a hostile public atmosphere that surrounds their trials. Indeed, when Katsav was indicted for severe sex offenses, he argued that the indictment should be dismissed due to the campaign of incitement and hatred, in his words, that was conducted against him by the media. He submitted to his judges thick volumes of publications that were prejudicial, in his eyes, to his right to a fair trial. He complained about leaks from law enforcement agencies that presented him as a criminal offender before his trial ended. Public remarks made by the Attorney General of Israel in this matter, and interviews with complainants and witnesses that declared he was guilty. In light of these arguments, the Supreme Court, considering Katsav's appeal on his conviction by the District Court, wrote that a trial by the press could create a diversion of public opinion against suspects and defendants, and it may also have influence over the court and to brutally harm a person's right to a fair trial. A similar view was expressed before by the District Court that tried Katsav in the first instance. Despite this statement, neither court has dismissed the indictment. The hostile atmosphere argument was used by judges only as a consideration to somewhat mitigate the sentence. The court listed 4 reasons for rejecting the influence argument. The first argument was Katsav and his supporters' involvement in the struggle in the public arena, which reached its climax in a widely covered press conference in which Katsav gave an aggressive speech against law enforcement authorities and against the complainants. The second argument was that the risk of influence of the publication upon the court was minor due to the huge scope of evidence that was submitted during the trial in comparison to the media publication that preceded the trial. The third argument was that as much as the accused's position in public life is higher and the offense attributed to him is more severe, the public interest in the affair is naturally wider, and it is not reasonable to dismiss the indictment for that reason. The fourth argument was that the publications on which the argument was based concerned the phase that preceded the trial and did not refer to the trial itself, and the testimonies that were heard during its course. The Supreme Court considered only substantial media publication that concerned the trial itself as such that could carry a prejudicial potential, while publications that precede the trial do not carry such potential. Putting aside the specific facts of the Katsav affair and its results, I think in principle that the above arguments should be reconsidered. With regard to the first argument, the Supreme Court held 35 years ago, in another famous affair of Asher Yadlin, that the accused has a right to defend himself also in public sphere, and not only in the courtroom. A public figure defendant that will pull his hands from the media's arena will leave it to his opponents only, and might lose out both ways if the court eventually rejects his due process argument. Regarding the second argument, the court should consider not only the quantity of the publications, but also their content and weight. There might be a few publications which their content could carry a heavy prejudicial effect. The third argument does not give the proper weight to the fact that a due process violation argument due to hostile public atmosphere shall be raised frequently in public figures' trial. As for the fourth argument, a later case of the Supreme Court held that the Katsav ruling should not be interpreted as denying the right to assert due process violation due to a trial by the press that took place before the actual trial has begun. The fourth argument should also deal with the legislative presumption to which we referred in the beginning, that there might be an influence also upon professional judges, and with other Supreme Court's rulings that recognize the reasonable possibility that media activity shall actually affect court cases. Thank you very much.
Thank you, Dr. Akina. And now for our fourth and final speaker in this panel, before we open the discussion to the audience, Mr. Evgeny Avov, who is chairman of the Russian Press Council. And I understand that your main message is that the interpretation of the discussion of court proceedings in mass media should be done under the context of actual political situation and actual state of the press in each different country, because the situation in each different country is not the same when you're talking about the freedom of the courts, the freedom of the press, and the legal situation. So, Mr. Avov, please.
So that was a half of my speech.
Thank you very much, Mr. Moderator. I'm going to speak a bit about a Russian Russia case, and because in our country, in the professional community, both in the judicial community and in media community, there are a lot of speculations about the statement that widespread coverage of court proceedings in the press and on social networks undermines the legitimacy of judicial procedures. And we agree, and we think that this statement should be considered in the context of actual situation on a country-by-country basis. By the way, at the end of this month, at the end of September, as part of the All Russian Journalists Forum, we shall discuss once more the problem of media pressure in context of courts. We shall discuss it with courts counsel. And this is not the first time we have addressed this problem. 2 years ago, in 2011, we discussed the draft version of the Code of Judicial Ethics, Russian Code of Judicial Ethics. And above all, in this draft, there was a clause which read, the judge should be or shall be independent of the parties to the case and society as a whole. So actually, it's no one would argue that against the independence of the judge, of the judiciary, from the parties to a particular case. that's obvious. But independence from society as a whole, to our mind, deprives the courts of recourse to civil society. And actually, at least in Russia, it increases their dependence on political authorities. And by the way, in 2012, the judiciary took account of our suggestions, and so they didn't include the statement of society as a whole in their code. However, a lot of senior members of judicial body, judicial community, continue to secretly dream about the idea of being fully isolated from the society and press in particular. By the way, recently we reopened the topic of judicial pressure, but in the opposite direction. That is, pressure exerted by judges, or better to say prosecutors, on independent media. That's really the case in Russia now. Because, you know, many people worldwide, not only in Russia, are familiar with the court cases brought against, for instance, businessman Mikhail Khodorkovsky in Russia, against Navalny, the opposition leader, against the punk band Pussy Riot. So I think nobody would argue that these cases should have been under the radar of press all the time. And but those cases, those very scandalous cases, they are on the surface, and so they are very well publicized. But behind the scene or under the surface, there are thousands, hundreds or even thousands of smaller cases which refer to some local businesses or local cases, and which are mainly covered by the local press, and which in many cases were very clearly ordered by certain interested parties. So our position is that if the educated, socially active part of society examines such sort cases for itself and draws its own conclusion, usually very different from those of the court. So it's not society's problem, it's the problem of court. And the problem manifests itself in different countries, we're sure, but the scale depends on the state of civil society and depends upon the internal political realities. The problem goes beyond the relationship between the courts and the media. In Russia, for example, the problem recently gave rise to the so-called public examination of the judicial decisions against Khodorkovsky, which was staged, which was initiated by the Russian Presidential Council for Human Rights and Civil Society. And so the group of highly recognized experts examined court decisions against Khodorkovsky, and they came to very critical findings of this as a result of this examination. And afterwards, those highly critical findings led to attempts to initiate criminal proceedings against the experts themselves, whom the prosecutors accused of displaying bias and exerting pressure on the court. So that was also purely Russian case, I think. So within the framework of our discussion, we insist that the phrase pressure of the court should only refer to administrative pressure or the issues of personal threats against judges, especially in respect of their careers. Judges are, after all, public figures, and one of their functions is to resist pressure from elements of society and from press also, which is pushing for unjust rulings. At the same time, certain members of the judiciary, dreaming of the independence from the society as a whole, are inclined to interpret any protest that's outside their courtroom or any publication in media as pressure of the court. By the way, we in our council we are working in very close contact with the Council of Judges. Actually, a representative of Council of Judges is part of our press council. So, and we have considered several cases, several claims where we actually supported judges against unfair publications. And unfortunately, one of the difficulties of highlighting certain lawsuits in Russia is journalists' failure to comply with basic professional standards. Primarily, the need to balance out biased opinions and convey the views of all sides of the conflict. And this refers not only to independent media, this refers to state media and especially to TV channels in Russia. And in the end, it's worth mentioning the widespread interpretation among Russian journalists of the term objective court reporting. In our mind, this objective court reporting is impossible by definition, since the very fact of choosing to cover a particular trial condemns the journalist to subjectivity. Classical journalism in Russia shows a strong inclination toward human rights, typically allowing some distortions in favor of the defense. But on the other side, on the other hand, some Russian media, mainly state media, under the guise of journalism, often feature press releases coming from police or coming from prosecutor's office, which reflect only the position of the prosecution. So that's so despite the basic rule that a report must state the positions of all parties to the conflict, there is no balanced representation to speak about as yet. So that's the Russian case. Thank you very much.
Thank you so much, Mr. Edward. Stay here for 1 more minute because I would like to ask you to look at the big picture by average.
I think those who are usually on the side of fair solutions, so media and defenders. Usually defenders in Khodorkovsky's case, they really suffer. Or in Pussy Riot's case. Media, I even would say that media in less suffers, because media punishes itself. That's in many cases. Yeah. So I would say that in your case, it's defenders. I see.
Okay, thank you so much. Gentlemen, I would like to ask you, before we open the discussion to comments from the audience, I would like to ask you a question that bothers me personally as a journalist, as a legal journalist who covers the legal arena. And I would like to ask you for your opinion if you would agree to distinguish between two kinds of defendants, two kinds of criminal trials being held. One is a trial against ordinary people, people who have committed crimes, maybe murder, maybe rapes, and those cases are getting a lot of media attention, being covered by the press. The second kind is public officials, politicians. We have many of those who were investigated and being indicted. Some were sentenced here in Israel in the past 2 decades. Would you agree that there must be a difference in the media treatment towards those two categories of defendants, and that maybe there should be more freedom to watch closely and to cover and report more closely the criminal proceedings that are involving people who are in the eye of the public, I mean politicians, public officials? Please take the microphone. There's a button there. You can press.
To be asked. Yes, I think that from a South African's perspective, one must bear in mind that the sub judice rule really comes from the time of juries. That's where the origin really lies. And that they would seclude them and put them somewhere. That's the first point. And now that's no longer the case in South Africa, no jury trials. The point is, ultimately, according to our Constitution, everyone, Section 9 of our Constitution, is equal before the law, public official or not. With us, I had once to preside on a person who had killed his children during the night. And it was just terrible, the media. You know, it was clear they were against this man. He had pleaded guilty, but the question was, what would be the sentence? Would it be life? Fortunately, we do no longer have the gallows, but in this case, it is life or not. I don't want to sort of sound high, but it is, for me, as a judge, it was irrelevant. I don't want to sound clever, but it should be irrelevant, and it is irrelevant for judges. Judges are trained to ignore all this. And so I would say equality. I'm not far against this high idea that you say, if you've had some punishment, I like the approach that someone being punished by the press or that because all circumstances can be taken into consideration. Moral considerations is the game of when you punish someone. So everything can be taken into consideration, but for me, it's really irrelevant, and for trained judges as well, all judges know that it's really irrelevant what happens. When Oscar Pistorius' case comes up, there'll be a trained, very trained judge who will only decide on the evidence. And if then in the end he's possibly found guilty, they could say, you know, he was already made out to be bad, at least by some. And that could be a factor, and it wouldn't be wrong because you can look at everything. So equality, maybe I'm an idealist, but equality before the law. Thank you.
Okay, thank you. Dr. Walter, let me ask the question in different perspective. Suppose you're a chief editor of a newspaper, major newspaper here. Oh, so okay. And as a chief editor of a newspaper, you're making professional decisions about how to report on a very high-ranking minister in the cabinet, maybe the prime minister himself. And after a while, we hear that there's a criminal investigation ongoing against this person, maybe the prime minister. And every day there's new details coming out of the investigation. What would, in your opinion, would be a legitimate decision on how to report on this new angle of what's going on with this high-ranking political figure?
As simple as you put it, to report about that. It is one thing to bring legal analysts and experts who sit on TV on the studio and analyze the legal questions of a particular topic, but it's another thing to bring the witnesses there. It's another thing to try and affect whether you do it intentionally or by chance, right? So I'm serious. See, I'm a big fan of free expression, member of the press council, but it's one thing to report and it's another thing to take the court and bring it to your studio. That's wrong. And if we say that it's wrong for public figures, it's also wrong for the lay people, in principle and on the substance. On the substance, because some of the famous cases deal with lay people who no one knows. See the AIPCE case, the famous one, the murder of the Jewish kid, the Amos Baranis, and the Zadorov case. I mean, Zadorov, no one knows who this guy is, but still the case is so famous because of the circumstances. Therefore, there should be no double standard about that. With power comes responsibility, and the media is the more powerful body in any democratic state, and therefore it should be the most responsible body.
Thank you. Dr. Naknimun, as a legal counsel that gives advice every day, on a daily basis, to how to report the news on one of Israel's main media outlets. Where do you draw the line? Let's go back to the Katsav case, for instance, because we all heard of him, we all know him, and he can't come here to debate with us, he's in prison.
The holidays over.
Yeah, he got a 24-hour...
First furlough since he started his
yeah, he's spent almost 2 years out of his 7-year sentence, and he just spent 24 hours at home, but luckily he came back, he's gone back to prison. So let's go back to the Katsav case. And I'm taking you back in time after the end, to the end of the criminal police investigation, and the case is going from the police to the prosecution to deliberate. And by that time, the police issues a statement that said that it had gathered enough evidence to justify an indictment in the police opinion. And all the journalists who cover legal matters get this statement, and of course this makes headline news. And do you agree that in order to explain to the public what is going on, all the legal details, is it justified, is it legitimate to invite to the studio, as Dr. Watad said, a legal expert to make comments, commentary, or to analyze the specifics of the legal matter?
Of course it is. It works there. Of course it is legitimate because it's a part of the freedom of expression principle that everybody has a right to express its views, especially if we're talking about professional views. I would like to add also that a few months later, the Attorney General of Israel himself sat in our studio and in an interviewing panel, and he said that Katsav is...
in the program Meet the Press,
Meet the Press, on Saturday by Dana Weiss, and he said that we're dealing here with a criminal offender. He said it specifically, and he got some criticism about it from court afterwards. So it was one of the reasons why Katsav said his trial should be dismissed.
Was it a fair play that the media interviewed the Attorney General, that the Attorney General said this statement out loud to the public? Was it? Would you change anything in retrospect?
I don't think so, because for sure it's legitimate that the Attorney General would sit in a TV studio and say his views to the public. But if Katsav would have agreed to sit with him, or maybe not with him, but in another program, and explain his point of view, but he didn't want to do it. He did it also, we all remember, in a press conference, which he did not want to take any questions, and the only one who asked him questions was someone from Channel 2, Gadi Sukening, and he got hot water from Katsav to his questions. So it was Katsav's choice not to sit there and to balance things. He chose to do it his own way, and I think he did it wrong.
Okay, thank you. Mr. Orlov, same question to you. Is there and should be difference between reporting on regular criminal proceedings and criminal proceedings or trials of political figures?
Actually, first, yeah. From the first glance, there should be no difference because all of them are equal against the war. But I know that in all codes or guidelines, in all university standards, there are special rulings about coverage of public figures, people who are of public interest. So probably this means that there should be some specifics in covering first and second category results.
Okay, thank you very much. We're going to turn now to you if you have any questions to the panel members or any comments.
5 minutes.
We have 5 minutes to do so, so yes, please.
First, I think there should never be any difference between there's only a difference in the terms of privacy. The possibility of the public to identify the accused. But the main point for me is in the German system, we haven't got too much rules for handling, reporting sub judice. The only one, and the important one, is you never should report in a prejudice way. And the risk we try to minimize by this rule is not to influence the court. Because we assume, and the courts assume, and the whole system assumes that the courts are independent. And we have no empirical evidence that this is out. The risk we try to minimize by our rules is the risk for the accused. If the sentence is not guilty, this is the main sense of this rule, because he has to bear all the burden, which is not to avoid if you report in an unfair way.
Okay, thank you. Any other remarks, comments, questions? Yes, please.
Just one short comment. Just a matter of principle, I would like to remind that the fact that the process is public is also a guarantee of due process. It's not only a problem, it's also a guarantee, because clandestine processes would be the worst thing.
So, do you suggest that the media coverage that makes sure that the public the public process, the public trial remains public, remains open doors, is actually helping the fairness of the trial?
Yes, I would say in general, media coverage is part of publicity.
Mm-hmm.
And the trials should be public.
Thank you. Any other comments? Yes, please.
Yeah. I'm Yujun, and I have a short comment about that. I think in a tolerant society, we need to go back to the basics. From the perspective of the media, what is the basic goal of the media? The main goal of the media is to make people informed with relevant information. On the other side, I know that the law is equal to everybody, right? So in a time of SNS, the court and the press might have a lot of chance to see and to reveal the public opinion. But my idea is that I have two conditions. The first one is it is not easy to find out the public opinion in the era of the SNS. In the world of the SNS, the opinion is feminine. So it is not easy the general idea. On the other hand, okay, let's assume that we found out the public opinion through the SNS. I think if the court is influenced by the public opinion, it is another type of utilitarianism, right? So we need to go back to the basics. So my comment is that the media coverage and the judge should be controlled by, not by the public opinion, but by the truth. You know? That is the basic idea of the journalism. Okay,
thank you. Did you refer to SMS, to texting from the courtroom? Yes. Yes. So let me just say that nowadays we have journalists who are more advanced than just texting or tweeting from inside from inside the courtroom. So you have several journalists sitting in different parts of the courtroom, and each one is tweeting to his list of followers.
It's even been allowed in conservative Britain on occasion from the court.
Yeah, I think that in that aspect we are a little bit more advanced than the Great Britain. Yes, final remarks, anybody?
Yes, low time.
Yes.
This is not a right of reply to that outrageous comment you just made. David Hunt. We have a very difficult case at the moment. Should judges be above press criticism? Because we, out of the Jimmy Savile case, we had a prosecution of Stuart Hall, another leading personality, who received a lenient sentence. One of the newspapers highlighted the fact after the lenient sentence that the judge in that case had had to resign 15 years earlier because they had been found in a gay brothel. And the brother of the judge protested and said this was outrageous and contrary to the code of ethics. What's the view generally about whether judges should be subject to the same criticism as any other person in a position of authority?
Let me just answer from my experience as a legal journalist that not only that we are sometimes criticizing judges to their judgments, on their judgments and their verdicts, we also report on the Commissioner of Complaints against judges. There is a special Commissioner of Complaints against judges, and although his decisions are mostly unpublished, many times they are leaking to reporters, and we were used to reporting on those matters in which make sides, different sides to cases are filing complaints against judges, and this is very embarrassing sometimes for the judges. But we try to do it in a polite and moderate way. Justice Dornes does that with her head because.
You must be sure on your facts. That's also important.
Yeah, we try to do that. I didn't say we succeed in doing that. So, thank you very much. Thank you, panel members. I think